Hi guys, and welcome to another episode of Atty Vlogger. Today we'll take up part 3 of the Personal Property Security Act or Republic Act number 11057 on enforcement of security interest. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, when we talk about enforcement of security interest, we're talking about the rights and remedies of the creditor, of the grantor or debtor as the case may be, and the rights of the buyer or other third person who may acquire the collateral. Okay, so let's begin with the rights and remedies of the secured creditor. The secured creditor can exercise his rights under the PPSA either extrajudicially or judicially. The only difference is in case of judicial exercise of his rights or remedies, we will have to follow the rules promulgated by the Supreme Court. Okay? If extrajudicially, then we just follow the rules provided for in the PPSA as well as its implementing rules and regulations. Okay? So the following are the rights of the secured creditor. First, we have what is called the expedited repossession, okay, repossession of the collateral. Second, we have the right of a higher ranking secured creditor to take over the enforcement. Okay? Third, we have the right of the secured creditor to retain or retention of the collateral. Okay? Fourth, we have the right to dispose or sell the collateral. Fifth, we have the special rights provided for under the PPSA and its IRR. And finally, we have the right to damages. Okay? Let's begin with the expedited repossession of collateral. Okay? So, upon default of the grantor, the secured creditor may take possession of the collateral extrajudicially. How? Provided there's compliance with two requisites, no? First, it must be stipulated that he has this right, no? And second, provided that it can be done without breach of the peace. And what is breach of the peace? It can be entering the grantor's residence, or there can be violence or intimidation, or in case the secured creditor has to be accompanied by law enforcement or the police to enforce his rights. So, okay? So, if the repossession can be done without breaching the peace, then it can be availed of. Okay, I'll talk about the case of breach of the peace later on. Okay, so if the right has been stipulated and it can be done without breaching the peace, then the secured creditor can take repossession of the property. Okay, if the collateral is a fixture, no, which has been attached to movable or real property, no, the secured creditor has priority. He has priority over all other owners or mortgagees of the real property and he may remove that fixture, no, to which the fixture is affixed. He can remove it from the real property only if he can do it with due care. Okay, and he can do this extrajudicially. Okay? But if the secured creditor cannot take repossession without breaching the peace, okay, meaning he has to there is entering of the grantor's residence, or he has to resort to other means that may breach the peace, then he should not take repossession extrajudicially. No, he has to apply for a court order and serve this application upon all the interested parties like the debtor, the grantor, the other mortgagees. No. Upon which the secured creditor will be entitled to an expedited hearing, okay, a very fast hearing, and if found to be warranted, no, if the court finds that default has occurred under the security agreement and that the secured creditor indeed has a right to take possession of the property, if the court finds the existence of those two, then the court will now issue an order granting possession to the secured creditor. Okay, so that's the expedited repossession of collateral. Second right is the higher ranking secured creditor can take over enforcement. Okay, so how does this work? No, if the secured creditor has a secured interest which has priority over another secured creditor or lien holder who is about to or has even commenced enforcement, even if the enforcement of that other secured creditor has started already or is ongoing. If there is a secured creditor that has priority, then he can take over enforcement. Okay? Why? Because he has priority. For the rules on priority, please just refer to my previous video. Okay, now this right to a priority may be invoked at any time before the collateral is sold or disposed of in any other manner, and the secured creditor can use any method to enforce, which is allowed, of course, under the PPSA or its IRR. Okay, so now we move on to the third right, no, the right to retention over the collateral. Okay. So once again, after default of the grantor, the secured creditor may retain the collateral either in full satisfaction or partial satisfaction of the secured obligation. Okay? How? By sending a proposal. Okay? He has to send a proposal to the debtor or the grantor. Okay? And third, to the other secured creditor or lien holder who has perfected a security interest or a lien through registration 5 days before the sending of the proposal to the debtor or grantor. Okay? Third, that's a third person. And fourth, to any other party who has an interest in the collateral who gave written notice to the secured creditor before the proposal is sent to the debtor or grantor. Okay, so just take note, even if there is the only way that this right can be enforced, no, the right of retention, is through the sending of the proposal. Okay, you have to take note of the people that must be served with the proposal. And how do we know if the proposal is sufficient? Well, the IRRs give us the rules, no? The proposal is sufficient first if it has a statement, no? First stating the amount required to satisfy the obligation. Okay? That's the first. Second, no? The amount of obligation proposed to be satisfied. Okay? Because again, remember, it can be total or partial. Okay? Third, no, that the secured creditor proposes, okay, to acquire the collateral which is described, no, in total or partial satisfaction of the obligation. And fourth, of course, you have to put the date after which the secured creditor can now acquire the encumbered asset. Okay? Then after that, the secured creditor may retain the property either for full satisfaction or partial satisfaction. However, there are qualifications, no? In case of full satisfaction, it cannot be had, no? Full satisfaction will not be granted, no, if there is a written objection which is sent within 20 days after the proposal has been sent to any of those parties who are required to be notified. Okay? So these parties can object, and they have to register their objections within 20 days from the time the proposal has been sent to them. Not the time of the receipt, the law says the time of sending. Okay? In case of partial satisfaction of the obligation, if this will only be granted if the secured creditor is able to acquire the affirmative consent in writing, affirmative consent in writing of all the addressees of the proposal, meaning he has to get the affirmative consent of everyone that he sent the proposals to within, of course, 20 days from the sending of the proposal. Okay? Next rule, no? After default, the secured creditor may sell or dispose of the collateral, whether through a public or private sale. Okay? Now, this public or private sale must necessarily be an auction, and I'll be discussing the rules on that later on. Okay? But the sale must, the property must be sold at the sale, no, in either its present condition, okay, as its present state, or following any commercially reasonable preparation or processing to make it more appealing to prospective buyers. Okay? The requirement here is that the secured creditor must act in a commercially reasonable manner. That's very important, okay? Because the law makes reference to that term repeatedly, okay? And how do we know if the secured creditor has been acting in a commercially reasonable manner, okay? First, if it is in conformity with the common practice or commercial practice among dealers in that type of property, okay? And the law says, no, specifically the IRR say that it will not be considered commercially unreasonable, or in other words, it will still be reasonable, no, even if a better price could have been obtained at a different time or place than that selected by the secured creditor, okay? Now, the secured creditor is given leeway under the rules, no? The secured creditor may select the method, the manner, the time, place, and he can choose to sell, to lease, to license the encumbered asset, no? Or the collateral individually or even as a group if it's more than one, no? As long as the following rules are complied with. Okay? Now, first, when it comes to a sale, no, whether it be public sale or private sale, it has to be done in an auction form. Okay, it has to be an auction because the word the law uses is shall. It shall be in an auction. Okay, so whether it's private or public. Second, it has to satisfy the requirement of being commercially reasonable. Okay. And finally, the disposition or sale has to be done in good faith. And the law gives us indicators of good faith. And these are as follows, no? First, the party or the entity who is presiding over the auction is an experienced dealer in that type of the property sold, okay? Second, if the participating bidders, no, in the auction, they do not engage in collusive practices that will prevent the free and open competition over the collateral. Okay? Finally, records, there must be records of the auction, no? Which identify the bidders as well as their submissions, which must be documented in writing, okay? And maintained. And finally pala, there's one more. The collateral or the encumbered asset must be awarded to the highest bidder, okay? In case of the highest bidder must fully pay, okay? Pay in full, okay? The bid price at the conclusion of the auction. Okay? That's the time limit set by the law. He must fully pay at the time of the auction. If he cannot pay during the time of the auction, what's the remedy? Then the law says the collateral or encumbered asset which is sold will now be awarded to the next highest bidder. Okay? So the next highest bidder will now be given a chance to fully pay for the asset or collateral sold. Okay? Now, in order to exercise this right to sell or dispose of the collateral, the seller must comply with the requirements of the law. First, he must give notice to the following people within 10 days before disposition. Remember, 10 days before the disposition sale, no? Disposition or sale, rather, no? These are the people he must give notice to. First, the grantor. Second, any other secured creditor or lien holder who was able to register notice 5 days before the notice is sent to the grantor. And third, notice must be sent to any other secured creditor who was able to send notice of his security interest to the secured creditor before the secured creditor has sent notice of the disposition to the grantor. Okay? So notice must be given to those people. That's the first requirement for the public or private auction to take place. Okay? The second requirement is that the secured creditor must cause the posting in the registry of the Land Registration Authority, no, of notice that describes the collateral, the method, the manner, the time, and other details of the sale, no. Okay, and this information shall be publicly accessible. Okay, and it is searchable, no? Because remember, in my previous video, I mentioned that the information in the notices in the LRA registry are public records. Okay, now I mentioned earlier notice to the grantor. This notice to the grantor may be waived after default. Okay, take note, the grantor may waive the requirement of notice. Okay. Now, in case of the secured creditor, in case he wants to maximize the sale, he is allowed to do so by making advertisements, no, in newspapers or TV, whatever, no, as long as it is for the purpose of maximizing awareness of the sale. So there will be more bidders. Okay? Now, who is the entity that the law allows to conduct the auction? It can be a government agency which regularly conducts public auctions in the course of its regular activities, or it can be a private entity such as auction houses, etc. No, but in either case, whether it be governmental or a private entity, they will submit the rules and regulations over the auction to the Department of Finance, and if the Department of Finance approves those rules and regulations, then the public auction will now be conclusively presumed, okay, to be commercially reasonable. Okay? In my opinion, the failure of these agencies or private entities to send the rules for approval will not necessarily prevent them from conducting an auction, because the effect in the law just says that it creates a presumption that the auction is commercially reasonable. So by implication, if they do not send the notice, the conclusive presumption of the sale being commercially reasonable is lost. That's the only effect, no? Okay? However, of course, let's wait for jurisprudence, no? And this is subject to the pronouncements of the Supreme Court later on. Okay? Now, at the auction, the secured creditor may buy the collateral. Okay? He may buy it at the public or private disposition, but only if the collateral is of a kind which is customarily sold on a recognized market, or if it is the subject of a widely distributed standard price quotation. Okay? Now, if the method of disposition is approved in a legal proceeding, whether it be judicial or administrative, then that is also conclusively presumed to be commercially reasonable. Okay? Now, in case of application of proceeds, no, let's say the thing is already sold. Okay? If the thing is already sold, remember, it's to the highest bidder who must pay the full price at the conclusion of the sale. And in case he cannot, it will be awarded to the next highest bidder. Okay? This is how the proceeds will be applied. Okay? First, the proceeds will be applied to the reasonable expenses for the taking, the holding, the preparing for disposition, and the actual disposition. In other words, the preservation and care of the thing. No? The proceeds will be first applied to those reasonable expenses, including as well attorney's fees and other legal expenses. Okay? Second, it will now be applied, the proceeds will now be applied to the satisfaction of the principal obligation, or the obligation that is secured by the security interest. Okay? And then after that, we now go to the satisfaction of the claims of subordinate security interests. No? In the former law, no, these were junior encumbrances or junior mortgages, no? As long as they are subordinate in priority. Okay? However, no, the proceeds will only be applied to the subordinate security interests if, okay, if, take note, if written demand and proof of the security interest is received before the proceeds have been distributed. Okay? Or if it's before its completion of distribution. Okay? Otherwise, okay, wala. Now, the rules on excess and deficiency. If the thing is sold and there is an excess, then the grantor is entitled to receive the excess. Okay? The secured creditor must give the excess to the grantor, no? But if there is a deficiency, okay, the general rule is that the grantor will still be liable for the deficiency, and the secured creditor can claim the deficiency or from the grantor. Okay? However, there is an exception. The only time that the secured creditor will not be entitled to deficiency or the grantor will not be liable for deficiency is if there is a stipulation saying that the secured creditor will not be entitled to the deficiency. Okay? Now, remember I said earlier the proceeds will answer for the reasonable expenses of the preservation and care of the thing. Okay? What if the secured creditor caused damage to the thing, no, or even loss, no, because of his failure to properly preserve or care for the thing with the diligence required by the obligation, no, which in absence of an agreement is the diligence of a good father, no. So the secured creditor, since he benefits from the expenses, no, through the proceeds, he's also liable for the value of any loss or deterioration which is suffered due to failure to preserve or take care of the collateral or encumbered asset. Okay? So that's it for the right of disposition or sale. Okay? Let's move on to the special rights of the secured creditor. Okay? In other words, on default, these are the following remedies which the secured creditor can exercise extrajudicially. Okay? He does not need judicial assistance. Okay? First, when it comes to accounts receivable, okay, the secured creditor may instruct the debtor of those accounts receivable, not the grantor, the debtor of the accounts receivable. Why? Because the grantor is the one who's supposed to receive those accounts, no? And he made that into a security, okay? So there is a debtor, no? So in this case, the secured creditor can instruct the debtor of those accounts receivable to make payment, okay, straight to the secured creditor instead of the grantor. And then the secured creditor can apply that payment now to the satisfaction of the obligation after deducting the reasonable expenses for collection. Okay? Second, if the collateral is a negotiable instrument which was perfected by possession, no, it's in the possession of the secured creditor, then the secured creditor can claim satisfaction either from the instrument itself or from the goods covered by the negotiable document of title. Okay? Now, third, if the collateral is a deposit account which was made in favor of a deposit-taking institute such as a bank, then the secured creditor may instruct the deposit-taking institute or bank to pay the balance of the deposit account to the secured creditor's account. How? By providing two things, no? First, okay, he has to give a copy of the security agreement which created the security interest. And second, the secured creditor must give an affidavit, okay, saying that default occurred and that he is entitled to enforce the security interest extrajudicially. Okay, and the final right of the secured creditor is of course damages, no? Damages are allowed under the implementing rules in case of any failure of the grantor to comply with the rules contained in the PPSA or the IRR. Okay? So now let's go to the rights or remedies of the grantor. Okay? The first right or remedy, no, is in case where the secured creditor is not complying with the rules of the PPSA or the IRR. Okay? In case the secured creditor is not complying with those rules, then the court may either order, okay, he may order or restrain. Okay, the court may either order or restrain collection, enforcement, disposition of the collateral, no, on terms and conditions which are appropriate to the circumstances. Okay, and the second right of the grantor would be the right of redemption. Okay, it's simply put, no, any party who is entitled to receive notice of the disposition, no? You remember I discussed to whom notice must be given, no? You remember, to grantor, to other secured creditor or lien holder who is able to register his notice 5 days before the notice is sent to the grantor, and third, to any other secured creditor who sent notice of his security interest to the secured creditor before the notice is sent to the grantor. Any of those people are entitled to redeem, no? They are entitled to redeem the collateral which is being sold. Okay? And how will they redeem? Simply by paying or otherwise performing the obligation in full. Okay? In full plus, okay? Plus the reasonable costs of expenses of enforcement rather. Sorry. The reasonable cost of enforcement. Okay? Now, this right to redeem is not applicable, no, in the following cases. There is no right to redeem in the following cases. First, if the grantor expressly makes a waiver in writing, okay, after he has been in default, then there is no right of redemption. Second, if the collateral has been sold, has been disposed of, or has been acquired or collected by the secured creditor, or if the secured creditor has made an agreement about the sale, disposition, or acquisition of the collateral, no? Then there can be no right of redemption. Why? It's already sold, no? There is nothing more to redeem. The right has been transferred already. Okay? And the final case when there is no right of redemption is when the secured creditor has retained the collateral following the rules I mentioned earlier, no, on retention. Okay? I discussed that earlier. Okay? Now we can move on to the rights of a buyer or third person. Okay? Or other third person, no? When we say buyer or third person, this is the person who is the highest bidder, no? He is able to acquire the collateral at the public sale, no? So the rules are as follows, no? The first rule is that if the secured creditor sells or disposes of the collateral, then the buyer acquires the grantor's rights, no, to the asset, free from all rights of other secured creditors or lien holders. Okay? The buyer at the public sale or private sale, no, provided of course it's a valid sale, acquires the rights of the grantor free from any and all other rights of any other secured creditor or lien holder. Okay, that's the first rule. Second rule, if the secured creditor leases or licenses the collateral, no? Leases or licenses the collateral, then the licensee or the lessee is entitled to the benefit of the lease or license, as the case may be, for the period of the term. Okay? He is entitled to enjoy his rights to the lease or the license as long as the term has not yet expired. Okay? And finally, in case the secured creditor does not comply with the rules I mentioned earlier on disposition, then the buyer or the licensee or the lessee will only be able to get the rights I mentioned earlier, no, if he is in good faith. And how do we know he is in good faith? He must have no knowledge of any violation on the rules of enforcement that will materially prejudice the rights of the grantor or any other third person. Okay? Now, let's just quickly go through the transitional rights, no? The transitional rights, the PPS, under the PPSA, no, they begin from February 9, 2019, which is the effectivity of the PPSA. Now, as to creation of security interests, no, the prior laws will still remain effective, okay, prior to February 9. Okay? As to perfection, perfection will continue until either it ceases under the prior law or until full implementation of the PPSA, whichever comes first, no? Whichever is earlier. Okay? When it comes to priority, this is determined by prior law if the security interest and the rights of competing claimants arose before the PPSA and the priority status has not been changed, okay, since the effectivity of the PPSA. So how will we know that the priority status has changed? Okay, it's changed only if first, no, the perfection took place when the PPSA took effect, but it ceased to become perfect, no, after the PPSA, or there is a change if it was not perfected on before the PPSA, but it became perfected after the PPSA took place. Okay? And finally, when it comes to enforcement, if any step or action, no, for enforcement was taken before the effectivity of the PPSA, then there is a choice, okay? Enforcement can be done either under the prior law or under the PPSA, okay? Except of course if it's subject to the enforcement is subject to a court proceeding, because if it is subject to a court proceeding, then necessarily we have to follow the prior law, okay? But that's all only for those prior to February 9. These are transitional provisions, okay? When it's 5-10 years from now, you don't need this part anymore, okay? Finally, when it comes to interpretation, in case of conflict between the PPSA, no, and any other law, the PPSA will govern, okay? Unless, of course, that other law, which most likely will be a subsequent law, specifically cites or amends the conflicting provisions of the PPSA, okay? So that's it for the enforcement of security interest as well as the transitional provisions of the PPSA. Okay, I hope you may have picked up a thing or two, and I hope to see you for my next series of videos. Okay, see you soon. Bye.